Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. The government's response to the BEIS Green Paper on corporate governance has been published. Key points are listed companies will need to report on the pay ratio between their chief executive and the average UK worker on an annual basis and report on any changes to that ratio. Listed companies will also be required to provide a clear explanation of any executive share-based incentive schemes. All significant sized companies will be required to explain how they comply with the Companies Act obligations to consider the interests of other stakeholders, particularly employees, when making decisions. In addition, significant sized companies will need to publish their corporate governance arrangements on their websites. It's anticipated that these changes will be implemented in legislation by mid-2018. Regretfully, the government rejected the recommendation that from May 2020, at least half of all new appointments to senior and executive management positions in the FTSE 350 and listed companies should be women. The recent case of Watson v Watchfinder highlights the importance of full board minutes and that boards need to give proper consideration to matters that they have agreed to determine. In this case, the parties entered into a share option agreement that included a general term that the option may only be exercised with the consent of the majority of the board of Watchfinder. Although it was agreed that the other requirements for a share option had been met, the share option was refused on the basis that the board consent had not been obtained. Watchfinder did not offer any explanation, and the evidence presented at court showed that the matter had been raised at a board meeting, but only one director had spoken to say he would be voting against the grant of the option. The court held that the clause did not give Watchfinder an unconditional veto, as this would have made the offer entirely meaningless. There had not been any proper consideration, and therefore the claimants succeeded in their claim. The recent case between Royal Devon and Exeter NHS Foundation Trust versus Atos IT Services UK concerned the deployment of an IT system. The trust terminated the contract and claimed against Atos for the expenditure it had wasted on implementing the system. Atos countered that such claims were barred because the contract excluded liability for loss of profits, business, revenue, goodwill or anticipated savings. At a preliminary court hearing, the court determined that the wasted cost claim does not fall under any of these categories of exclusion and could therefore proceed. Another recent case has demonstrated the court's strict approach at giving a literal meaning to the words in a contract. In this case, E.ON engaged a contractor to design and build 60 wind turbines. Upon installation, faults were found that had to be rectified at a cost of €26.25 million. The problem was largely due to a failure in a standard design code that E.ON had specified for use. The contract also included a technical requirements document that stated the design of the foundation shall ensure a lifetime of 20 years in every aspect without planned replacement. The contractor argued that it was not liable because it had correctly followed the design code, that there was a difference between a design life and an actual life, and that the technical requirements guaranteeing a service life of 20 years was tucked away and inconsistent with the general theme of the contract. The Supreme Court ruled against the contractor. It was not impressed by the argument that the technical requirements document was tucked away. It was part of the contract and therefore enforceable. In addition, the contractor was liable for any failures in the design code. A recent European Court of Human Rights ECHR case has clarified that before an employer monitors the emails of its employees, it must have clear monitoring policies in place and consider alternative, less intrusive methods first. In this case, an employee was dismissed for the private use of a business Yahoo Messenger account. The employer argued that the employee had been informed that private use of the internet could lead to dismissal because the company had previously dismissed another employee for the same offence and had communicated the dismissal to all staff. The ECHR, overturning earlier national and European court decisions, determined that notification of a similar dismissal was not an appropriate notice, and there had not been sufficient consideration to balancing the interests of the business and the right to a private life of the employee. Accordingly, there had been a breach of Article 8 of the European Convention on Human Rights, which provides a right to respect private and family life. We have previously reported on the Asda equal pay case concerning the gap in pay between workers in Asda stores and Asda's distribution centres. The Employment Appeal Tribunal held that the value of work between these two groups of staff is of equal value and therefore that their pay should be comparable. Permission has been granted to Asda to appeal to the Court of Appeal. The High Court in a recent case has reminded employers that suspension may be a breach of the implied duty of mutual trust and confidence, entitling an employee to claim constructive unfair dismissal. In this case, a teacher had been suspended without the employer first considering whether there was an alternative way of conducting an investigation. This case does not end suspensions, but underlines the importance that the employer first carefully considers whether a suspension is appropriate. We reported last month that the Tribunal Fees Order of 2013 had been declared unlawful. Consequently, until any new fees regime has been implemented, employment tribunal claims are free. The consequences of this are far-reaching. There has already been reports of claims being allowed to proceed out of time as a result of a decision, and a complicated process is being implemented to reimburse fees paid. It remains to be seen whether the infrastructure of tribunals that has been significantly reduced in recent years can cope with the doubtless surge in demand. The CMA has fined Ping Europe Limited £1.45 million for breaching competition law by prohibiting two of its retailers from selling golf clubs on their websites. Ping may still require online retailers to meet certain restrictions on their online sales channels as long as these are justifiable and comparable to the restrictions imposed on their bricks and mortar outlets. In another CMA announcement, the CMA has confirmed that it has withdrawn an immunity from fines against TGA Mobility. TGA, a mobility scooter supplier, has been under investigation since April for potentially breaking competition law by restricting its retailers from advertising prices online. The Modern Slavery Act 2015 requires large businesses to produce a yearly statement outlining the actions they have taken to combat slavery in their supply chains. Despite this legal obligation, it has been reported that 1 in 3 businesses are flouting the law. This lack of compliance is likely to ease the way of 2 private members' bills that have recently been introduced to increase the MSA obligations on companies. Thank you for tuning in for this month's Commercial Bulletin. For more information on any of these stories, please contact Radius Law or my colleagues at LexisNexis. We'll be back in November with more of the month's key legal updates.